authority they don't have. And if we don't stop them, it's going to get worse. All right, so moving forward from the initial magistrates' court, we went then further forward into the Crown courts, and we doing then with judges, and we went through the issue of the legal fiction. We got the judges to accept and acknowledge the legal fiction in the court, and allowed me to represent Mr. Roger Hayes, me as the flesh and blood man, and Mr. Roger Hayes as the legal fiction. And effectively, the first judge told the council to go away and prove its case. Now, what the council had done is put on the table a liability order that had no signature on it. So, liability order, no signature. Next time that document turned up in the court, it had a signature, which is itself extraordinary, because it wasn't on the day, so it wasn't proper evidence. So again, this just demonstrates the type of thing that's going on in the courts. Then we came up to the final hearing, and as you probably were, on the 7th of March we arrested the judge. The reason we arrested the judge is because we asked him whether he was on his oath of office. And what that means is he actually acting under common law? If he's acting under common law, there is a requirement A, he make a judgment based on the evidence that's provided, and B, that he listens to witnesses. We allowed witnesses to put forward their case, etc. None of that was allowed. It was a complete whitewash. And for 20 minutes, I had an argument with the judge about whether he was on his oath of office, and he prevaricated, he dodged, he dived, and all the rest of it. Now, how anybody can expect to get justice from a judge when you had an argument for 20 minutes, I don't know. He said, oh, I've been doing this for 20 years. I said, yeah, you're avoiding the question. If you don't answer the question, if you don't now in this group confirm that you're on the oath of office, I'm going to call the police. And we did, we called the police. A couple of young constables arrived, and we explained to the constables what was going on, and they just nodded and said, oh, yeah, okay, and they couldn't get out of their back there. So they don't understand the law, so we can't even rely on the police. That's why we're getting lots of people to turn up in the court, because that number of people in the court are the witnesses to what's really going on. Now they've stopped us going into the court, they're trying to close down to 2 people. So they're trying to outmaneuver it. We're fast reaching a situation where we literally will not go into the courts anymore, because these are not courts of law, they are places of business, and we're being stitched up. Okay? Now, in order to get to the position where we can do that, we have got to, if you like, replace their courts with their own courts. Because we are being invited to these courts, and in fact we have now set up our common law courts of England for the world, and we'll move slowly towards using those courts as well. This doesn't happen overnight, this is a process, and we've got to get used to talking about it, thinking about it, and then doing it, as we've been doing for the last 12 months. All right, so after the arrest of the judge, when there was nothing decided, they had a follow-up court case which I could not attend. I applied for an adjournment and also for a jury, because there was clear evidence of fraud having taken place in the courts. Of course, justice being what it is, they completely ignored me and said, no, we'll just find it bankrupt. So they actually proceeded with a bankruptcy against the legal fiction. And the legal fiction being Mr. Roger Hayes, which of course, as everyone knows, or people know, that's not me. So I had a decision then to make whether I should actually challenge the decision of the judge, or see what happens, see what the process was. And there's all sorts of different approaches. A lot of people, Rusty, Lockie there, welcome guys. Doing some brilliant work, in so much as they're really pushing the court system and giving them a run for their money. And this is what it's about. The guys have set up a lawful office in Hereford, and will be helping people out with documentation and so on and so forth. So these meetings, getting lots of people to these meetings, and then being able to draw on their experience is what this is all about. So, all right, so after the decision I made, which was basically to let things run, I then got a letter from the official receiver indicating that I was bankrupt. I then wrote to the official receiver and said, not me, this is the legal fiction. So this is the letter I wrote, and if those of you read it, I'm just going to go through it so you can actually see what the whole person. If you can't read it, then I'm going to read it out to you anyway, because I think I'm going to go through each of the paragraphs, explain what the object of the exercise is, what we're putting in front of the official receiver, and essentially the information that we're trying to get across to anybody who will listen today. All right, so the introduction was, I apologise for the delay in writing. I had to talk to the official receiver. The gentleman, his name is Martin Fulton, was assistant to the official receiver. And with most of these cases, you never deal with a top dog, because if they eventually are found to be wrong, they just blame their assistants, don't they? So you'll never get a letter from the official receiver. You'll always get something from the assistant. So they hide behind their desk and they don't get involved. So the conversation I'm having with Martin Faulkner, the gentleman who's supposed to be handling the bankruptcy of the legal fiction, Mr. Roger Hayes, he will never make a commitment. He will always push up the line and then it will come back to him. So you never deal with people making a decision. They've invited me to go and have a meeting with them, and I've said, sure, conditional upon answering these questions. I'll go through the questions with you. The letter reads, I'm in receipt of the correspondence reading the above matter. I'm advised that I'm replying in the capacity of a third-party representative for the legal fiction, Mr. Roger Hayes, an explanation of which follows in the body of this letter. This letter identifies 4 contentions in relation to the authority of the office of the official receiver. These contentions being, number 1, that the government has no legitimacy as a consequence of the loss of sovereignty of the magistrate Queen Elizabeth II. The point being that we have written to the Queen and we have asked is she still sovereign. The word sovereignty means that there is a supremacy. You can't share sovereignty, you either have it or you don't have it. And we have made this point to politicians, is that the Queen can no longer be sovereign if there is a superior authority being claimed by Brussels. And of course John Major did say that the Queen was now a citizen of the European Union.
On the website, you might read a statement on the website, which will show people. She's actually the statement on her website, yeah. How to read that statement she has in the
Yeah. And the point is, our constitution provides that our sovereignty is protected by the fact that the Queen is sovereign. If the Queen is no longer sovereign, what we're claiming is the people of this country are no longer sovereign. So somewhere down the line, the politicians have transferred our national sovereignty to foreigners. That's treason. Okay? There's no 2 ways about it. That's treason. If you ask them to explain it or answer the question, they ignore you. So the policy they have is, if the question is too difficult, ignore it. Right? So, that's right. That's exactly what's happened. And they think that if they continue to ignore us, that the problem will go away. So that was the first point that I wrote about. The second one was the authority of the office of the official receiver stems only from legitimate government. And is this currently null and void? So I was saying to the official receiver, he has no authority because the government has no authority. That Mr. Roger Hayes is a legal fiction, the liabilities of which do not fall to me, Roger Hayes. So again, I'm claiming the position that I am not the legal fiction. My evidence is that if the claim is against me, then there would be documentation with my signature on to support that contention. But of course, there are no documents with my signature on, therefore the only authority they have is through the legal fiction. And the purpose of the Insolvency Act was that it's not as a debt collection tool. The Insolvency Act is designed to protect the debtor from creditors. It's not designed to be used as a debt collecting tool. This is something that they, again, ignore. So there it is in the legislation, designed for a purpose. Now in my case, the council were claiming £2,000 from me. I had £2,000 in my bank account on that day. And according to their rules, they shouldn't have been bankrupting the legal fiction on the back of that. All right, I've explained, you might find it helpful to know that as chairman of the British Constitution Group, I'm involved in detailed research in conjunction with many of our members that has brought the legitimacy of the government into question. which in turn challenges the authority of our court system, as well as the authority of the office of the official receiver as an agency of government. So there it is, we're challenging the whole lot. In black and white, we're saying we're challenging your authority. Now, if anybody has got authority, it's simple, isn't it? They just explain where it comes from. They justify it. The points question outlined below are an endeavour to identify is there a common understanding with issues 1, 2, 3 above, and if so, what requirements, if any, you feel are obliged to meet. So I'm actually giving them an opportunity to negotiate the points with me. Point number 1, the government has no legitimacy. Briefly, the British people have an inalienable right to govern themselves. This right is guaranteed by our Constitution, the rule of law, a key element of which is the coronation oath. Her Majesty Queen Elizabeth II gave a solemn oath to govern us according to our laws and our customs. She has breached this oath by giving royal assent to international treaties which have subjected the British people to the imposition of foreign laws without our express approval, and by so doing Her Majesty has broken the contract she made with the people. Our position is that we are claiming that Her Majesty is under duress. Now, some people take the position that the Queen is involved and so on and so forth. It's not to our advantage to go around claiming that. We have got to try and get people on board. So our position is that we believe Her Majesty is under duress. In other words, she's been threatened, coerced, blackmailed, and so on and so forth. If she is involved, we don't have any evidence. It will come out in due course. So the sensible proposition, when asked to if you like, your view on whether the Queen is involved or not, we don't know. We can surmise. What we do know is that the decisions that she seems to be making are contrary, most definitely contrary to her coronation oath, and therefore that breach is unlawful. And in fact, in theory, she's committed treason against the people. So the sensible proposition is to claim that the coronation oath has been breached, and that we want redress. Now, the redress that's available to us through Magna Carta is Article 61, which says that if our grievances aren't addressed, they gather together 25 barons, and of the 25 barons, 4 barons go and have a meeting with the Queen and say, this is our problem, we want them solved. The 4 barons that went down to see the Queen, this is in 2001, were told by the butler to go away. So there's the backbone of the barons these days. We have approached the barons since then, and the bottom line is they're not really interested.
Do you have an account of what actually happened on that day or not?
We do. We've got the guys who were involved, so we can provide that. But yeah. Well, essentially, the 25 barons, there are about 60 barons in total that were prepared to stand up, and they nominated out of their group four of them who did go for an audience with the Queen, but they were declined the audience with the Queen, which is totally unlawful again. So from that point on, the barons should have gone away and roused the people, but they probably went and had a cigar and a whiskey and went back to sleep. So our position is that the responsibility now goes back to the people. Okay, so it's our job. They're not going to do it, we've got to do it. So we're building consensus on the back of that. Now, we're planning a constitutional convention, I believe in September. We haven't fixed the date yet. And what we're going to do is we're going to make a declaration as to our position and have conventions around the country. And we will invite judges, politicians, senior police officers and senior military to take part in that convention. I don't think they'll turn up, but that's fine. We've done the right thing as far as we're concerned to invite them.